Being threatened with eviction can be frightening, but you do have legal rights. First, a landlord can't evict you from your rental unit without a court order.
There is a limited exception that lets a landlord change your locks temporarily, but only if you're behind on rent, and if they alert you at least 5 days beforehand that they plan to change your locks. And plus, once a landlord does change your locks, you can ask for a new key at any time, and your landlord has to give it to you almost immediately, even if you don't pay them $1 in back rent.
If the landlord changes your locks without taking those steps, then they've broken the law. If that happens, you can visit your nearest justice of the peace. They will have paperwork you can complete, and you should be allowed to get an order called a writ of re-entry that will require the landlord to let you back into your rental unit.
The only way for a landlord to evict you legally is by filing an eviction lawsuit against you. But before your landlord can file an eviction lawsuit, they must first give you a notice to vacate. That is a written document that would have a deadline for you to leave. Your landlord cannot file an eviction lawsuit until the deadline in the notice to vacate has passed.
The notice to vacate must also be delivered to you in the right way, either giving it to you in person, sending it to you in the mail, or affixing it to the inside of your main door. Or if you don't have a mailbox and you have a keyless deadbolt or a dangerous pet that stops the landlord from coming into your unit, then the landlord can put the notice on the outside of your door in a sealed envelope.
If your landlord does not deliver the notice to vacate in the proper way, or if they file the eviction lawsuit against you before the deadlines in the notice to vacate, then the judge should dismiss the case against you.
Once your landlord files an eviction lawsuit, you're entitled to have a copy of the lawsuit delivered to you by a deputy, constable, or sheriff before the court takes any action. The first page of the paperwork you receive will be a citation. It will list the date and the location where the eviction hearing will be held.
The Justice of the Peace will decide whether to grant the eviction during the eviction hearing. So if you have witnesses or evidence to offer, you should bring it with you to the hearing.
If the Justice of the Peace decides to grant the eviction, they'll sign an order called an order of possession. If you want to appeal that order, you need to do it within 5 days of the hearing. In order to appeal the eviction judgment, if you're income eligible, you can submit a form called the Statement of Inability to Pay Costs. They'll have that form at the Justice of the Peace, and you can ask them for help on how to obtain it, fill it out, and submit it. Submitting the Statement of Inability to Afford Costs will do two things. First, it serves as an appeal of your eviction judgment, so that in itself is your appeal up to county court. Second, it will take care of the appeal bond that you may see in your eviction judgment. It'll be listed that you may owe money and have to pay a bond in order to appeal your eviction. By filing the Statement of Inability to Afford Costs, you are taking care of that appeal bond. However, if you're being evicted for non-payment of rent, you will have 5 days from the date that you file the appeal to pay 1 month of rent into the court registry. You can contact the court for how to do this, but the Statement of Inability to Pay Costs will not cover the 1 month of rent in a non-payment of rent case.
After 5 days, if you have not appealed the order, then the Justice of the Peace can issue a second order called a writ of possession. That directs law enforcement officers to force you to leave the rental unit and to remove your property from it.
A writ of possession is very serious because law enforcement officers can physically force you to leave and put all your belongings on the curb. You should make plans to move your belongings before the Justice of the Peace can issue a writ of possession.